and with consent, because at that time it was unclear whether that was, authorized. And today, they're reluctant to withdraw treatment without consent because, similarly, they lack clear legal authorization to do that. They're chilled by the prospect of legal sanctions because consent of the substitute decision maker is viewed as a sine qua non for withdrawal. They need a carrot to do otherwise. And the typical response to bad law claims is safe harbor immunity. And there's 4 different approaches to this. It's the Uniform Health Care Decisions Act approach, right? What I'm calling the Ontario model, Texas model, and then I want to look at really quick at conscientious objection. So the Uniform Health Care Decisions Act is drafted, all uniform laws are drafted by the National Conference of Uniform Law Commissioners, which draft all types of uniform laws, many of which are adopted in Wisconsin, like the Uniform Determination of Death Act, Uniform Anatomical Gift Act. So most of their laws actually have 50 state adoptions, right? They draft it and the legislatures pass it. The Uniform Health Care Decisions Act hasn't done quite so well. It's only had a handful of adoptions. But its basic approach has been adopted pretty widely and mirrored in other states. And so let's just take a typical illustrative statute, a state that adopted the Uniform Health Care Decisions Act, Tennessee, says a healthcare provider may decline to comply with a healthcare decision that requires medically inappropriate healthcare or healthcare contrary to generally accepted healthcare standards. You're allowed, right? And then it says, if you're going to do that, all you have to do is make reasonable efforts to assist in the transfer. If the transfer can't be effected, then you shall not be compelled to comply. Sometimes, as where I am in Delaware, there's a twist that if you can't transfer, then you have to keep treating. And that's called the so-called, that's referred to as treat-till transfer. But normally there's no treat-till transfer. So let me just stop real quick. What this statute basically says is, if what the surrogate is asking you to do is contrary to generally accepted healthcare standards, then you don't need to do it. And you're free, you're safe. You have immunity for refusing to comply with something that doesn't comply with generally accepted healthcare standards. So, are there, though, generally accepted healthcare standards in this area? For example, that would apply in the case that we started with. Well, but this is telling enough, though, right? I mean, the whole point is, if it's that mixed, the answer you might actually say is no. Let me say that the Tennessee law, right, basically looks what I'm saying providers were looking for, right? Safe harbor immunity to practice the medicine that they think is right. The problem is that safe harbors only work when the language is concrete and precise. It's clear, concrete, and precise. This language is not, right? Generally accepted healthcare standards, you can stop if it's medically inappropriate, which is later defined in the statute as being not likely to provide a, quote, significant benefit, right? Not clear when this applies to any particular case. And so the key language, right, this key language is just too vague. And given significant variability in how in end-of-life care, it's hard to know what is a generally accepted healthcare standards. There's too much uncertainty over what conduct is actually protected by the statute, right? Where is the safe harbor, right? There's very little consensus in this area, right? It's pretty much limited to brain death, maybe anencephaly, 22-week and under gestation infants, physiological futility, right, where it won't even produce an effect at all. But these are all very narrow categories, right, and apply to very few of the relevant cases that we're talking about. They don't even apply to the case that we started with because, as we heard, dialysis would have been affected. Dialysis would have achieved what dialysis is supposed to do. Might not achieve any benefit for the patient, but it's going to do what it's supposed to do. Right, we tried to develop quantitative measures of futility. We couldn't agree on those. We couldn't agree on what the relevant threshold trigger is. If it's only effective in 1% of cases, does that mean it's ineffective? What's the right number? People couldn't agree. Some people thought even if it works 20% of the time, it's futile. And even if you could agree on the threshold, right, 1%, half of a percent, there's difficulty in extrapolating these population-level studies to individual patient cases. Right, the essence of futility is overwhelming improbability in the face of possibility. And so even we couldn't agree on quantitative measures, couldn't really agree on qualitative measures either, right? What's the right benefit burden? What's the right quality of life? What's the right cost per quality? No consensus. So, in just a quick example, right, 35% of physicians said they would treat for septic shock in a vegetative patient, right, 65% said they wouldn't. And these examples go on and on and on. There's this extreme variability in how these cases are treated. So it's hard to say that there is a standard of care. And at some level, there's just some uncertainty over what is, in fact, the very goal of medicine. Is it to cure disease, alleviate pain and suffering, or is just merely prolonging corporeal existence a legitimate goal of medicine? Some people say it is, some people say it isn't. So where we ended up is that futility is treated like how Potter Stewart said we have to identify obscenity, which is we know it when we see it. We can't come up with ex ante criteria. But it's not just the ambiguity. Doctors are actually creating the very standard of care that they don't want to comply with, right? The standard of care is based on what is customarily done. And so as we dialysize the PVS patients and so forth, that becomes the standard of care. Right, and just a quick example of that, right, famous case published in JAMA, Dan Merenstein, right, in terms of PSA testing for his patients, did absolutely the state-of-the-art thing, accepted at the national level, but still was sued and lost the malpractice case because the standard of care in Virginia at the time was to do, you might say, the bad thing, the wrong thing, but that was the standard of care, right? So in some sense, it's hard to be innovative and move forward. You're sort of anchored by custom. So the result of this ambiguity, the result of this uncertainty, is that many institutions don't have futility policies. To the extent that they have them, they don't use them. Again, physicians wanted a green light, but the state Healthcare Decisions Acts give them only a yellow light, and the yellow light is the same as a red light. But there's another model out there, call it surrogate selection. All types of surrogates, agents, proxies, guardians, must follow certain decision-making standards. Generally, follow the specific instructions of the patient. If you don't have those, then follow at least the patient's wishes and preferences to the extent they're known. And if you don't have that, then use a pure objective standard and act in the best interests of the patient. When surrogates deviate from these standards, they can and should be replaced. Even in Wisconsin, statute says the healthcare agent shall act in good faith consistently with the desires of the principal with any valid declaration. And if they don't, the court may direct the agent to act in accordance or rescind all powers. Have you seen surrogates replaced in this way, where they were not acting faithfully with respect to the wishes of the patient? So 24% yes, 8% they didn't do it, but they saw it done, 68% no. This approach, surrogate replacement, to resolving futility disputes was famously failed in the Helga Langley case, which probably remains the most famous futility case discussed in the literature. But it's proven successful over the past year, right? The clearest example are surrogates with a material conflict of interest. Financial, or sadly a frequent type of case, is where a parent or caregiver has basically abused, beaten a child, and now the question is whether the child should be removed from life support. Obviously, many times they don't consent to removing the life support because that would expose them to homicide charges. So clearly they have a conflict of interest. Other times, the surrogate is just acting inconsistently with the patient's preferences. A New York court replaced Dorothy Levatis's daughter and agent because she was asking for care that was inconsistent with that specified in the mother's advance directive. These are all just in the last year or so. In Southern California, a court replaced one son as surrogate where he was asking for overly aggressive treatment that the court did not think was what the patient would have wanted or was in the patient's best interest. At the Mass General, Boston, the judge told Barbara Howell's daughter that her own personal issues were impacting her decision and urged the daughter to, quote, refocus her assessment. Surrogate replacement, and this is all very refined in Ontario, where they have a special tribunal which does just this and regularly replaces surrogates who do not act in the patient's best interest. So surrogate replacement works, but not always. Why? Well, there's often congruity between what the surrogate is asking and what the patient would have wanted, right? Sometimes the surrogate is faithful. Or even in the case we started with, I think the quote of the case was, there was a detailed advance directive, right? And so if the surrogate is, we're pretty confident that what you're asking us to do is what the patient wanted. Sometimes that's not, that doesn't cinch it because even, for example, the Consent and Capacity Board in Ontario is able to say, well, yeah, I know they said that, but they didn't anticipate these precise circumstances, and they're able to get around even that. More frequently, though, than the congruence of surrogate and patient is the fact that we don't know what most patients would want because we don't do enough good advanced care planning. And so it's hard to show that the surrogate is deviating from the patient's preferences if you don't know what the patient's preferences were. Bob Truog says, look, surrogate selection, you can do that in every state. It's well-settled law, and that will resolve most of the tough futility cases. To the extent there's still some left over, and those just cave in and do what the surrogate wants because there are going to be so few of those. That's not pleasing to everyone, and so the argument is that we still need a dispute resolution mechanism for those intractable cases in which the surrogates are, quote, irreplaceable. And the main model for that is, as we were going to hear about, is Texas.